Maharaj versus City of New York.
Good morning, Your Honors. Chief Judge Wilson, I would like to reserve 2 minutes for rebuttal, please.
Yes.
Thank you. May it please the Court, my name is Joshua Annenberg. I'm appellate counsel for the plaintiff appellant Maharaj. The Second Department in this case erred in applying primary assumption of risk to the injurious crack and hole in the tennis court. It did not follow the rule and good public policy set by this court in Siegel versus City of New York within Morgan, which states a negligent condition occurring in the ordinary course of any property's maintenance is not subject to primary assumption.
Aren't some premise hazards inherent in the sport? And I'm not only talking about something like Turcotte, which the cupping of the racetrack. I'm thinking more along the lines of some of us might remember playing stoop ball or stick ball in the street, and you might fall into a pothole, and some of us may have twisted lots of ankles playing those games as a child. Now that, I would think, is inherent in the game of stick ball or stoop ball, that you take those conditions as they come because that's where you've chosen to play.
But not in our case, not in Maharaj. Maharaj is really modeled after Siegel. And by the way, to be a little more specific, Your Honor, with respect to that question, I think this court in the Custody case exempted liability for private play within sidewalks or within private driveways. The Custody case and the primary assumption of risk cases that this court has decided and in Siegel goes to the issue of playing sports in a given designated venue, such as we have here, the tennis court at
Well, it's a
issue here.
little odd here, I guess, isn't it, that cricket is normally played, I'm not a cricket player, but on a grass field, I think?
I understand.
And this is played on tennis courts where the nets are removed?
The net's removed.
And cricket is not normally played on a hard surface of any sort.
That's correct.
And the grass field that you would play cricket on would have a lot of irregularities.
Yes, but that's not our case.
Right, because Mr. Maharaj decided to play cricket on a tennis court.
I don't think it was that he unilaterally decided.
Well, no, he needed to have other people to play with.
It was part of the Queen's Cricket League, and that while it's not explicit in the record, I think it's reasonable to either assume or reasonable to think that since he was part of a league and since they played on the tennis courts where the tennis courts were adjacent and both nets of both tennis courts removed, that the City of New York did so. They know they were coming there. They know they were going to play there. And it's reasonable for the City of New York.
But counsel, to follow up with the Chief's question, again, I am also not an aficionado of cricket. Everything I know comes from watching period movies. But from what I've seen, part of the game is you hit the ball with some kind of paddle-like device, and then at some point you have to go running off like a shot. And I'm questioning the choice to even play that game on a tennis court, much less one that had big cracks on it. So to the extent that it might have been a bad idea to play cricket on a tennis court or a cracked tennis court, who bears that risk?
Well, going to one specific fact on this, Mr. Maharaj was playing outfield just as opposed to batter.
I don't know what that means.
It's similar to baseball.
Okay.
Quite frankly, I watched a YouTube so I can get to understand how to play cricket. But it's not that much different than baseball.
It looks like baseball.
So he's out in the outfield and he's catching the ball. Now the outfield, I'll say, is part of the tennis courts. But if I can move for a second, I understand the court's questions, but it's not going to matter whether he's playing cricket on a tennis court or there's a tennis court or people are playing tennis court on the tennis court. Here, what matters...
No, but the question I'm really asking is, why is he playing cricket on a tennis court and not cricket on a nice, soft field of grass?
I don't have an answer for that, and it's not on the record. It was never asked, and it was never answered. I think this is within the City of New York. This is what we must be doing.
Are there signs that prohibit the use of these tennis courts from non-tennis purposes?
Not that I know of. The record is silent in that regard.
You know, part of what I've been wrestling with is how far your position goes, right? So I think in a lot of areas, you find asphalt gets cracks during the winter because of freezing and cooling, right? So is the city or any municipality then liable for any crack that emerges? You could trip on pretty much anything, I think. And what does that mean for, the ability to keep these properties open to the public as opposed to someone, heading out and seeing a crack, somebody that works for the city seeing a crack and saying, I'd better shut it down because I don't want to run the risk of liability. I know you're saying here that the crack was significant and you have photos in the record, but what kind of lines would you have us draw around that?
I think the lines are clearly set by this court previously in the Siegel case within Morgan. The line that, in that case, and that I think is quite applicable here, is that, as I started out, the negligent condition occurring in the ordinary course of any property's
So
maintenance.
a small crack is okay. I'm trying to understand what a rule is that you would have us adopt. A small crack
Well,
is okay, but a larger crack,
I understand, but then it begs the question, how small is small, how big is big?
that's my concern.
However, so to answer that, this court and the appellate divisions and the lower courts have already dealt with the issues of trivial defects. So to that extent, the municipality or any private owner would have a defense and can move for summary judgment on trivial
And you don't think
defect.
that this would, that if we were to adopt your position, that would induce municipalities to err on the side of shutting public facilities down while they figure out, how to get them spick and span?
No, I don't think so. I think that.
Why not?
Why not? Because my answer is that not every roadway has potholes. Not every sport facility in the city of New York is riddled with cracks and holes.
A lot of them have some cracks at different times of year.
Then they need to, our position is, then you need to maintain the premises, and maybe this is the qualifier, in the reasonably safe condition.
Counsel, can I ask a factual question? And I just don't know this. Was this an organized game that you had a permit for, your client had a permit for, or did they just go on a tennis court, take the nets down and play?
It would seem to be that it's an organized game. It was not asked or answered in the record as to the issue of the permit, but as I mentioned before, since they went to the court and the nets were down, it would seem that it's reasonable that they had a permit, that the city of New York knew that they were going to be
Well,
there.
if you're playing cricket on a grass field, which has some irregularities and has turf, is there an inherent risk of tripping?
I believe, Your Honor, you're almost asking me like the Ninivagi case.
Well, I'm actually just asking you a fact about cricket.
Fair enough. So,
I mean, I've seen some cricket highlights on TV, and I see people diving and sometimes tripping and tumbling
will
in
that be
the outfield, on grass.
on grass?
On grass. I haven't seen cricket played on asphalt.
I understand.
So would you agree that there's an inherent risk in tripping and falling when you're playing the outfield in cricket? You don't have to agree.
It's an interesting question, but
Right.
if you're playing, I would say that if you're playing on grass and where it's usually played, I still think that the manner in which the premises are maintained, whether it's going to be grass or whether it's going to be asphalt, is not a risk inherent in the game. In my discussion,
I'm sorry, you have to slow down. The manner in which the
in
field
other
is
words,
maintained is
like you
not a
said,
risk.
if there are waves or holes or whatever it is in a grassy
Yeah.
field, that grassy field, to me, is comparable to the tennis court in this matter. So it's the game surface. If the game surface, if the court, if the grass field has holes or has some type of depressions in it, because it is not maintained properly, reasonably safe in the ordinary course of its maintenance, then it would fall within the
I think I'm
confines of
trying to
Siegel.
ask something different, I think.
I'm sorry, I'm not
No,
understanding.
Okay, so I think earlier you said that cricket is played on grass typically, right?
Yes,
And that grass fields have irregularities in them.
yes,
They're not perfectly smooth like the putting surface of a golf course.
fair enough,
There's some bumps, and the same with soccer fields and so on, that people play on grass, right?
fair enough.
And that those irregularities, an inherent risk is that you're going to trip on something like that. I mean, people, get their cleats stuck in turf, or their shoe slips out from under them if it's a little bit wet, or there's a depression, or a little bump that they don't anticipate, and they trip.
I think here,
So, is there an inherent risk in tripping on a grass field in cricket? You could say no.
I think no, because, if I may, I think the whole issue goes to what it was discussed in Morgan and Siegel as to the sine qua non, the necessary condition of the risk. And
What about sliding, counsel? I feel like in cricket, sometimes, I think those things are called wickets.
yes, the
I feel like sometimes I see people sliding to get to a wicket before a ball gets there. Is that,
Well,
am I right?
that would be what I call the method and manner of play.
Okay.
That's how you play the game.
But
you
does the
don't-
method and manner of play also include a risk that's inherent in the game? In other words, if you slide into the wicket, is that a risk inherent, and you injure yourself doing so, would that have been a risk inherent in the game?
Yes, absolutely.
right,
The method and manner, if you get hit in the head by the ball, if you slide into the wicket, if you, if there's some
Okay.
other game of body checking, that,
So let me ask you this. If you slide to the wicket in a game of cricket being played on a tennis court, and you're injured worse than you might be sliding into the wicket on grass, is that a risk that's been assumed of the game as well?
well, if the player so chooses, and that's how the game, and if that is an option on how to play the game, then I'll answer yes.
So the
because-
last question in my syllogism is this. If you accept the assertion that tripping is a risk inherent in the game, and I know you kind of
I
said no to
don't.
that, right?
Okay.
But if you accept that assertion, then the risk of tripping on an asphalt surface and being injured worse than you might be injured on grass would also be a risk inherent in the game.
Not if the premises here was maintained in a reasonably safe condition. They could have played cricket. See, with respect to the issue of the risk being the sine qua non, being the necessary condition, and then what I call the manner and method of how the game is played, they could have played just fine without the crack and hole.
But
So
they
is
could
it your
have played
position
on,
that no matter what sport was being played here, that crack being so obvious and so obviously increased the risk of any sport being played, whether you were playing tennis or cricket, over and above the normal defects of a surface? Is that your position? And if that is your position, did you preserve that argument? Like, where below did you raise this argument that crack so increased the risk of injury above and beyond regular maintenance?
That is not our position on this appeal. When we talk about the issue of preservation, what we're arguing here on appeal is that the crack and hole is not subject to primary assumption of risk whatsoever, because it's not a risk inherent in the game, and it was a negligent condition
But
occurring in the ordinary
to
course.
what game, to just follow up on Judge Singas's question, to what game is a crack in a pavement inherent?
Well, I would say there's no such game.
So the answer to her question is,
But in answer to the question, with respect to the issue of the open and obvious doctrine, outside of primary assumption of risk, the open and obvious doctrine does not gain a dismissal. It only goes to the plaintiff's culpable conduct, to the plaintiff's culpable negligence. Here, as I'm arguing that this crack and hole is not subject to primary assumption of risk, even though, I'll grant you, it is open and obvious. But with my position that the crack and hole are not subject to primary assumption of risk, All that open and obvious condition does is put into play CPLR 1411 of comparative negligence against Mr. Maharaj, which I've said quite openly in my brief. He is subject to comparative negligence.
Thank you.
Thank you, Your Honor.
Good morning, Your Honors. Excuse me, may it please the court? Ingrid Gustafson appearing on behalf of the city. I'd like to focus mostly on the merits, but I do just want to touch very briefly on preservation and point out to the extent that plaintiff is still pressing the sort of sweeping distinction that he pushed in his brief between the method and manner of play and the conditions of play. That contention, which is contrary to 40 years of this court's precedent, is entirely unpreserved, is undeveloped in the courts below, and should not be reached by this court. I think the plaintiff, to the extent he is arguing that the assumption of the risk doctrine does not apply to negligent maintenance claims ever, I think that is also unpreserved. But I would like to go ahead and turn to the merits. And I will.
Could I just ask you, sir, is there anything in the record about whether or not the players had a permit to play cricket on this court?
No, there's nothing in the record about that. And to the
So
extent,
there's no indication that the city signed off on removing the net and having a game which would otherwise be designed to be played on grass and where injuries might be less severe. No indication that the city approved that in the record.
that is correct. And it's the city's position that to the extent that the plaintiff here knowingly, and I think there can be no dispute that he knowingly chose to play cricket on a tennis court.
Where are the cricket courts in New York City?
I do not have that information.
Are there
I do
any?
believe.
Are there any?
I believe that there are. I mean, this is outside of the record, Your
No, I
Honor. I think
understand.
when the city redid
Publicly
these.
available information.
Well, based on, I mean, just this park, when the court redid this park in 2016, I believe it actually did put in.
Do you think that you could
cricket.
play cricket, for example, on the public courts on Randall's Island? There are large grassy fields there that are used for sporting activities.
I mean, I think there are lots of grassy fields, certainly. So, I mean, those would be alternative options for playing cricket.
Can we talk about that big, gigantic crack running through the middle of this tennis court? You know, I think counsel has your adversary has a good point, that the first thing people who work in this area think when they see that is that's a big, open, and obvious crack. But I also think he's correct that goes to comparative, and I think I understand where he's coming from when he says that's really separate and distinct from assumption of the risk. So can you somehow connect this crack to assumption of risk, or do we have to let it survive summary judgment?
Absolutely, Your Honor, and in two different ways, both because the risk presented by cracks and imperfections are inherent in the game of cricket, and also because of how this court has applied the assumption of the risk doctrine to conditions. It has explicitly incorporated open and obvious into the doctrine. There's a special rule.
Where do we do that?
Starting in Turcotte, and the court has recited the principle repeatedly, including in Morgan, that where assumption of the risk applies, the duty of premises liability is to make the conditions as safe as they appear to be. Where a condition is of play is open and obvious, it is among the reasonably foreseeable and assumed risks.
So that
in
means
that
you
location.
incentivize the premises owner never to make a repair.
I disagree, Your Honor,
Okay,
and that's.
tell me how New York City is incentivized to make these repairs if we say summary judgment was properly granted here in your
Absolutely.
favor.
Absolutely, and I think this is a critical point because it goes to the interaction of the premises liability background principle that the city does not dispute applies to everyone, and the assumption of the risk doctrine. The assumption of the risk doctrine is very narrowly cabined by this court. It only applies to certain people engaged in certain activities, often in certain locations, and with respect to certain risks. So in a narrow piece of the background premises liability principle, the duty is modified to make conditions as safe as they appear to be. But anybody else who doesn't fall in the scope of the doctrine, as plaintiff himself points out, pedestrians, bystanders, children of a young age.
So if Mr. Maharaj was
inexperienced-
just walking through the field, they could sue you?
I mean, the assumption, I mean, they could, I mean, assumption, I mean, anybody can sue, but the assumption of the risk.
Well, you wouldn't have this
doctrine-
defense, is my point.
Absolutely. Also, the
What's
assumption
the
of
logic in that?
I think
What's
it's
the logic in that?
it's a design of the doctrine, because the doctrine is meant to protect against the crushing liability from the heightened risks of sports participation. If you are participating.
Well,
in sport-
yes, okay. But that's tied to the fact that there's some social benefit from having venues where people can indeed recreate. And what's the social benefit to a venue which is so dangerous?
Well, I
Where if I just walked by, or Mr. Maharaj walked by, then he could sue you.
I mean, I think as was pointed out earlier, someone can trip on anything. The doctrine, the
What
heightened
is the
risks.
size of this thing?
If I-
that
if
he
I-
tripped-
if I may-
No. What's the size of what he tripped over?
He gave very different measurements over anywhere from 2 to 8 inches wide, 2 to 4 inches deep. This particular portion of the crack was 7 feet long. I mean, I think there's no dispute. that
Doesn't
if you-
sound like just a thing that's on the ground, right?
It's a
It took a
significant.
long time to get this, to be of that decayed condition, no?
I think that there's no dispute in the record that it is a naturally occurring condition from repetitive cycles of
Would you
freezing.
agree that this would discourage people to use this property?
I think, some people might. Make
Doesn't
a
that work
decision.
against the purpose?
I don't think it does, Your Honor, because
Well, if the social benefit is to have venues where people can recreate, and people will be discouraged for fear of injury, I mean, I think most people might not take their child to this particular area to learn tennis.
If I may frame it a different way, I mean, the city has 4,500 courts and fields, and it is inevitable that they are going to develop cracks and holes and surface imperfections, and it's going to be impossible to keep them in perfect condition.
That's what happens when you
Additionally,
have millions of people in a city, but there are things called budgets.
If I could refer, I want to sort of refer back and finish my prior point, though, about the heightened risks of sporting activities. Just as you're more likely to crash into someone and get injured when you're playing a sport, you're also more likely to trip and fall when you are running, jumping.
Would he have a stronger case if he was playing tennis? Does it matter that he was playing a sport not intended for playing on that particular field?
I don't think it changes the result, because I think the assumption of the risk doctrine would apply in either case. But I think the fact that as an adult plaintiff knowingly chose to play cricket on a surface that was not designed for it, to the extent that was heightened
Does the
risks.
city in any way indicate that it prohibits certain uses of the court?
No, it hadn't. And usually there isn't a duty to warn of open and obvious conditions in any event, but I also think what we are trying, there's limited space in the city, and its facilities are put to multiple use. I don't think we necessarily want to restrict that, but to the extent there were heightened risks, as an adult, plaintiff could freely assume those. But fundamentally, the risk here of tripping while playing on an outdoor
Well, it's a
surface.
great argument for comparative negligence, for sure. But the question is whether or not you can even proceed with this defense.
Absolutely, Your Honor. This court, again, has applied the assumption of the risk doctrine to claims of negligent maintenance, and the way that it is
So is there
defined
any
inherency-
room in our jurisprudence for a duty on, in this case, the city, to maintain the tennis courts or other recreational venues?
Well, I think that's the background duty, and it's only going to be displaced in narrow circumstances for people. It won't apply to concealed conditions. It's not going to apply to conditions that are unique and unreasonably enhance the risks over and above those inherent in the court. So there is all of this background liability that
Why doesn't this crack fit
incentivizes.
that second category?
Yeah. Why doesn't this unreasonably increase the risk inherent in the game?
Yes, Your Honor. And I would note that plaintiff has sort of affirmatively abandoned that argument now. It was abandoned in the briefing in any event, but has affirmatively abandoned it at argument. That's because the exception goes to conditions that are unique and that increase the risk over and above that inherent in the sport. This is not unique. Cracks and holes in outdoor surfaces are common and inevitable
But the
and
measure
natural.
of it, is it not? I mean, that doesn't even sound like a crack or hole. That sounds like a fissure. I mean, it's not.
It's a significant crack, but I think
I
looking
mean,
at
if this was on a road, you'd have to close the road.
I'm not sure there would be
unless you've
any
got a
restriction. I would note that there are
truck
other
tires.
limitations of the city's liability on the
What's the
road and
difference?
recognition.
What's the
of-
difference between this crack and the torn net in Siegel?
Absolutely, Your Honor. I do want to make a sort of framing observation about Siegel, which is that this court said it was a close and difficult case. The difference is what the court in Siegel focused on was that it was a defective safety feature that was not inherent, it said, in the court of tennis. And in Bukowski, this court picked up on that distinction, and it actually put this case together with Owens, which is an unreasonably enhanced the risk case. And it said that defective equipment is different than suboptimal conditions. I would submit that we're in the suboptimal conditions world. But I do want to address this idea of the rule of Siegel that plaintiff keeps pointing to. Siegel never once articulates the rule that plaintiff would have this court adopt. What the court said was this condition is not inherent, therefore ordinary negligence principles may apply. It did not, plaintiff sort of flips it around and says, well, this is a claim of ordinary negligence, therefore the doctrine doesn't apply. But that's not how this court has ever articulated the rule. And if that had been the rule announced by Siegel, custody would have come out, which was about a height differential in the roadway would have been very easy. You would have just said, well, the assumption of the risk doctrine doesn't apply, which is not the line that this court drew.
Can we go back, if we can, to one of Judge Rivera's questions? So what incentives does the city have to maintain sporting facilities specifically? And let's set to the side the question of whether a pedestrian is going to randomly wander through them.
I mean, I think liability, beyond the...
Yeah, but under the rule that you are asking us to adopt, seems to me that liability would not readily lie for something like significant cracks in a surface. Agreed?
It would be depending on whether they're open and obvious, but I think
But
yes.
if there's not liability that would lie there, and again, set to the side, if you would, a pedestrian, and let's focus on just the athletes that are using the facility, what's the incentive to keep the facilities in some sort of proper maintenance? I don't mean the next day after a crack arises, but on some regular schedule.
Well, as the government the reason why these parks and facilities exist is to provide a place for the citizens of the city of New York to carry out sports and recreational
So
activities.
the check is sort of the political pressure of having the facilities available, but not a liability check as you would otherwise have in a negligence regime, it sounds to me.
I do think that there is still a liability check, because if you let the facility fall into disrepair, you're still liable for concealed conditions, you're still liable for unique...
What's the line then between disrepair and what we have here? Because I think you're telling us that this is not on the disrepair side of that line, yeah?
Well, I think what I'm saying is it falls, the threshold question is always going to be, is it inherent, before you get to the question of has there been a breach?
Could a surface be so riddled with whatever you want to call them, cracks, ruts, chasms, that it would have fallen into disrepair and give rise to liability?
I think, again, I just want to say, I'm sorry for this minor
I might be
quibble.
missing your point.
We're not saying that you first determine whether there's disrepair, right? Because that's putting sort of breach before duty. But rather, there is a category shift probably at some point, where you go outside of the usual rule for conditions, which is those that are open and obvious, and that to those that are unique and unreasonably enhance the risk above those inherent in the sport. A chasm that you would fall into is probably not, that's probably not an
You
inherent
think there's
risk.
some line
sports.
between suboptimal conditions and disrepair, and once you cross it, that there could be recovery?
There are certain conditions, certainly, for which this there could be recovery. But with respect to cracks and holes, I don't see how you draw the line and still maintain this doctrine in this area, which I think still preserves the benefit. It certainly furthers the policy principles as announced by the
You
sport
draw the
2 years
line
ago
at
in
maintenance.
ratings.
You say if it's a maintenance issue, that's not independent of primary assumption of risk, and if it's not a maintenance issue, like maybe a net that the owner installed in their tennis court, that would, at least theoretically, be outside the scope of primary assumption.
We know that from Turcotte and Maddox that the assumption of the risk doctrine applies to claims of negligent maintenance, and this is certainly a claim of negligent maintenance too, so I don't want to draw that line.
So where do you?
I draw it where this court has already drawn the lines, which is that when you look at conditions, the question is, are they, if they're open and obvious, the risks they present are usually reasonably foreseeable, which is one of the ways you get to inherency. But there's an exception. The limitation comes from the exception to the doctrine, which is it unique, and does it unreasonably enhance the risk above that inherent in the sport? I think Siegel sits a little uncomfortably with those general rules that the court has drawn. I think this court recognized it was a close case and did sort of seek to sort it later in Bukowski. I think I sort of sort Siegel along with sort of the exception to the doctrine. I don't think there's any evidence in Siegel that the tear in the net was a thing that commonly happened, and I think. The idea of a defective safety condition, a safety feature, which is really supposed to protect you, actually doing its exact opposite. I think there's something there about unreasonably enhancing.
Did the court
risk.
actually say anything of what you've just said? Did the court actually put it in those terms?
A defective safety condition, yes, that was the basis on which this
That is
court
working
sorted it.
contrary to what its purpose is.
It didn't put it that way. I mean, the court explained it in Bukowski, I think, and it sorted it sort of outside of the suboptimal.
So your red light is on.
conditional
So
rule.
just so I fully appreciate this distinction you're trying to make.
Yes, Your Honor.
Given the hole, the crack, the fissure, whatever, that's in this record, Mr. Maharaj cannot sue, in your view, because he's playing, he's assumed the risk. But if he was just walking by, and he injured himself, he could have sued, or
Yes.
not because it's open and obvious, that's his problem.
He could have sued, and we would, and the usual principles would apply. But again, I think that's a feature of the doctrine. It's meant to only prevent heightened risks of sporting activities. It doesn't insulate from premises liability, and the city's position is that it
Even though in
doesn't.
some sense, he would not be using it for the purpose that it exists, right? If he's just kind of walking by, I don't want to go around the park, I just want to cross through the park, which is not the purpose for that court. The court is for play. He can sue. But when it's being used for play, put aside for the moment the cricket versus actual tennis for one moment.
Yes.
He can't sue.
Yes, and I think that is a
And the
feature of the doctrine.
incentive for the city is that someone will walk by and injure themselves as opposed to the players.
Sure, or a young child or a novice player, depending on what the
Even though
risks
people
are.
would likely not be doing that, right? They would not be walking through these areas because they're recreational areas or they're in tremendous disrepair and they don't want to take the risk.
I mean, and if I may answer
Yeah,
that, Your
and then
Honor,
I'm
I
done.
think this is why the court drew the line where it did in custody, which is that it drew the line around designated sporting facilities and excluded streets and sidewalks. It didn't say all defective conditions on outdoor surfaces, no matter what, are excluded from the doctrine. What it says is, we're worried about sweeping in too much. We're going to go to where the purposes of the doctrine are served, and where the defendant is actually encouraging sporting activities, which are in sporting facilities. Duty rules aren't going to be perfect, but What this court did in custody is it placed the boundary of the rule around a location where its purposes are most likely to be served. That is, the people who are there are playing the sport and have assumed heightened risks. And it is true that it is less likely that other people will be there. But the city's position is that it still has an incentive and that it has not, abandoned this park or any of its park, but in fact still regularly maintains and inspects them.
Thank you.
Thank you very much.
Thank you, Your Honors. I just wanted to make one point. Opposing counsel started out with respect to the issue of preservation, and I know Judge Singas, you raised that question. I just want to address it and go back to it. Our position is, as laid out in our brief, that we have fully preserved our current argument. In the opposition to the city's summary judgment motion at Record 155, even in the lower court, the plaintiff's opposition said as follows: "It has long been established that the doctrine of assumption of risk does not exculpate a landowner from ordinary negligence in maintaining its premises." So I brought that forth in my reply brief. I brought the issue of preservation in my reply brief. I brought the issue of preservation in my principal brief as well. I just wanted to clarify and make sure it was clarified to the court that we have certainly preserved it. And I also cited the case of the Tolero against Tolero, which is a preservation case decided by this court. And the holding in the Tolero case by this court is as follows: "It is well established that questions raised in the trial courts or in the record, even if not argued in the intermediate appellate court, are nonetheless available in the Court of Appeals." So to the extent that on appeal before this court, we have made our arguments. It is preserved from the basis of the summary judgment motion and plaintiff's opposition below in the lower court and pursuant to Tolero. And in addition, I would just say that, interestingly enough, while we raised that position in the opposition to summary judgment, the City of New York, defendant City of New York, did not submit a reply affirmation to our opposition. I know that they don't have to, but if there was an issue of this matter on the issue of the negligent maintenance and primary assumption of risk not applying, they certainly had the ability to raise that issue in a reply. They did not. They did not submit a reply, and there is no legal or factual counter steps that they could have done. They waived the issue on reply, and as factual, these cracks are of course long-standing, as the second department noted, and the City of New York did not even bother to inspect for 4 months from April to August 2015. They didn't bother to inspect it, but if it's open and obvious for the plaintiff, it's open and obvious for the defendant as well.
Thank you.
Thank you.